Dear friends, good morning to all. This is your RAPETI Suryanarayana advocate from Vizag. In the earlier sessions, I gave many lectures with regard to various topics. All those lectures are useful, helpful, important to the practicing advocates, law students, and to students who are preparing judicial competitive exams and other competitive exams. And those lectures are also helpful to the public for legal awareness. In the previous session, I gave a detailed lecture with regard to decree. In this session, I would like to give lecture with regard to kinds of decrees. How many kinds of decrees are there? Let us see in this session. In the previous session, I said that what do you mean by decree? Decree means the formal expression of an adjudication which the court expressing it. That means the court expressing decision conclusively determines the rights of the parties with regard to all matters or any of the matters in controversy in the suit. I hope it is clear to all. That means conclusively determines the rights of the parties of the suit with regard to matters in controversy in the suit. Conclusively determines, that means finally determines the rights of the parties. With regard to controversy matters, with regard to controversy matters in the suit between the parties. That means what is controversy between the parties? That controversy will be decided finally by the court and determines finally, that means conclusively, and gives a decision by way of formal expression of an adjudication. That is nothing but known as decree. Next, what are kinds of decrees? Let us see. Decree may be preliminary decree, final decree, partly preliminary and partly final decree, deemed decree, ex parte decree. There are 5 kinds of decrees. First one, preliminary decree. Second one, final decree. Third one, partly preliminary and partly final decree. Fourth one, deemed decree. Fifth one, ex parte decree. Here, just now I said about decree. What do you mean by preliminary decree? Preliminary decree means is a decree when further proceedings have to be taken before the suit can be completely disposed of. Decree is preliminary when further proceedings have to be taken before the suit can be completely disposed of. That means I am saying that decree is preliminary when further proceedings have to be taken. That means when further proceedings are required for what? for disposal of the suit completely. That means for disposal of the suit completely, what is required? Further proceedings are required. I hope it is clear to all. Then, such decree is nothing but known as preliminary decree. Decree is preliminary when further proceedings have to be taken. That means when further proceedings are required for the disposal of the suit completely. I hope it is clear to all. That means in preliminary decree, further proceedings is required for the disposal of the suit. That means something is left which have to be decided by the court. It is nothing but preliminary decree. That means up to some extent is decided by the court. That remaining extent is not decided. So that decree is nothing but known as preliminary decree. That means further proceedings are necessary or required for the disposal of the suit completely. Such type of decrees are nothing but known as preliminary decrees. That means something is left to be decided by the court. I hope it is clear to all. Then what is final decree? Decree is final when adjudication completely disposes of the suit. That means when the decision completely disposes of the suit, then such decree is termed as final decree. I said that in preliminary decree something is left which have to be decided by the court for the disposal of the suit. If nothing is left, everything is decided by the court and completely disposes of the suit by the court and pronounce or gives a decree, such decree is nothing but known as final decree. I hope it is clear to all. In preliminary decree, something is left, whereas in final decree, nothing is left. That means everything is decided. Every issue is decided by the honorable court and finally disposes of the case or suit and passes a decree. That decree is nothing but known as final decree. Whereas in case of preliminary decree, something is left and something is required for the disposal of the suit completely. Whereas in final decree, nothing is left or nothing is required for the disposal of the suit completely. Why? Because everything is determined by the honorable court and passes a decree finally. So such decree is nothing but known as final decree. I hope it is clear to all. Let us go to the next point. Next one. What is next one? Partly preliminary and partly finally. I hope this is some important and logical. Partly preliminary and partly final. That means the decree is one. In the decree, partly preliminary and partly finally. That means partly final decree is also present in it and partly preliminary decree is also present in the decree. Simultaneously, proceedings have taken place before the honorable court and passes a decree. That decree is partly preliminary and partly finally. Example to this: if suit is for possession of immovable property with rent, A files a suit for possession of immovable property with rent. That means he files a suit for possession and also for rent. Then the decree passes with regard to the possession of immovable property. That is nothing but known as final decree. and the decree passes with regard to rent of such immovable property is nothing but known as preliminary decree. That means here the suit is with regard to possession and also rent. That means the court passes a decree. In the decree, final decree granted with regard to the possession and preliminary decree granted with regard to the rent. This is nothing but known as partly final and partly preliminary decree. Partly final decree and partly preliminary decree. I hope it is clear to all. This is one type of decree. Let us go to the next. What is the next one? Deemed decree. Deemed. Deemed means it's deemed to be termed as a decree. What is deemed to be termed as decree? Rejection of plaint. The rejection of plaint shall be deemed as a decree. It is also stated in section 2 subsection 2 of Civil Procedure Code. Decree shall be deemed to include the rejection of plaint. That is nothing but stated in Order 7, Rule 11 of Civil Procedure Code. Rejection of plaint deals in Order 7, Rule 11 of Civil Procedure Code is nothing but rejection of plaint is nothing but known as deemed decree. I hope it is clear to all. And the determination of any question within section 144 of Civil Procedure Code is also comes under deemed decree. What is section 144 of Civil Procedure Code? Application for restitution. If the application for restitution, any question arises and that question determines, then it will be termed as deemed decree as per section 2 subsection 2 of Civil Procedure Code. I hope it is clear to all with regard to deemed decree. Let us go to the fifth one, that is nothing but ex parte decree. Already in the earlier session under the title ex parte decree, I gave a lecture. Better to refer that one. Ex parte decree is nothing but in the absence of one party. That means in the absence of one party, the court will pronounce a judgment, pronounce a decree in favor of presence party and against the absence party. That is nothing but known as ex parte decree. Why? Because one party is absent, not appeared before the court. Then in favor of one party who appeared before the court, in favor of that party, the decree will be passed by the court. That decree is nothing but known as ex parte decree. I hope it is clear to all. So kindly share my videos, like my videos and subscribe my channel. Thank you a lot.